because those aren't allowed by right. And I think that that's important that we get it done. It's a privilege to get a special use permit, as my buddy here, Ed, told me at the meeting. So we need an enforcement officer.
How's the ordinance?
If I could add, I mean, the topic of enforcement ties in to some extent to the discussion that hopefully we'll have time to discuss in that regard, especially as permit review standards. So I'll leave it at that for now.
So for the renewable, I guess we're kind of at the junction point. Does anybody need to go over the procedures of developers go to the PSC? Any questions there? Just kind of summarizing that out. If the direction is to work towards a workable ordinance, then that's the direction we go. But we need to see if we have consensus here.
And it definitely sounds like the position of most everybody in this room is to go to a local ordinance. But certainly there's never a case where the state of Michigan or any state that has control of local land use ordinances. It never works well because you don't ever want the state to control your land use development. So that certainly shouldn't be an option. And I think we need to move forward quickly on establishing a workable local ordinance, because we are at risk, as Brad mentioned, we are at risk of the state putting utility solar panel farms anywhere in Cheboygan County. We don't have any control over that right now. Yes, they can. I mean, if we turn them down locally, they can still go to the Michigan Public Service Commission. But having an ordinance, and an investor who's looking at Cheboygan County, if you have an ordinance that shows where these industrial utilities can go, they might not go to the state. And that might deter them from within certain areas of Cheboygan County. So I think we need to move forward quickly, try to establish a local ordinance, and hopefully get away from the state, and hopefully the next legislature that comes in will try to change Public Act 233, because it's not a good public act for local land use development at all.
Real quick for everyone's edification, the current moratorium expires in early March. The board does have the authority, however, just so you know, to extend that if need be. So if we're talking time frames here, I thought everyone should be reminded that, again, the moratorium expires in early March.
You can shorten it up too.
Well, the way it reads is it may be repealed if a workable ordinance is drafted and, of course, adopted by the board. So it may be repealed earlier than in 1 year.
That would happen at the same time in the process.
Right.
Well, right.
Yeah, that's what I'm thinking, is take that one we already have, I spent so much time on, and kind of vetted it to the public. And, you know, if there's something wrong with it, review that, and it kind of gives us a roadmap. Looking at it, I'm not sure outside maybe the areas what would be wrong with that, but I just haven't read through the whole thing.
So it looks like we're two things. One, develop the local ordinance and massage language, and the other is to actively look, this board has to actively look at employing and enforcement. Correct?
Could I have just one more question? Obviously, we're not alone in this. Have you talked to any neighboring county leadership?
All the time.
Right.
We are all members of different committees.
I just wondered if there's a common theme that mirrors what we're thinking, or, you know, how are they addressing certain situations?
The NIMBY thing is pervasive.
I bet actually people in Wisconsin, commissioners call me because they've seen it on the news and some of the postings of how they can stop and do this. Other counties most people want to have control over it. That is the common.
So you guys are talking?
Oh, it's constant.
Okay.
Address that a little bit. In Michigan, multiple municipalities can do planning and zoning. So you have cities, villages, townships, and counties. So countywide zoning, there's only a few counties in the state of Michigan that do countywide. Us and Emmett are the closest here. But if you go to Charlotte County, they have the townships do the zoning. So Oswego County is kind of a hybrid. There's countywide zoning, but they have contractual relationships with townships and things like enforcement and other things like that. So just so everybody has the context of what that looks like. So as far as uniformity, that can make it a little bit difficult to see. One thing we'll do moving forward is we'll have research done on the workable ordinances that we're aware of in the state, because these are kind of new hybrid ordinances. They're in the framework of under influence by 233, which PSC processes its own specific process. What they look at under that may or may not be able to be integrated into our workable ordinance. It might, but it hasn't been tested yet, legally or written. So this is a new kind of era for us, and the state seems to be trying to exercise that more. We have discussions, on housing regulations that the state may do, and so I don't know if this is a kind of new situation in the state where we'll have these hybrid situations between state acts and local authority, but it clearly is that way on renewables in Michigan, and we're navigating through that. So,
And quickly, Mr. Lawson stole a little bit of my thunder, but for Mr. Cazzoli's edification, for more specific context, in Cheboygan County, we missed our zoning for 18 of the 19 townships. See, for Burke Township, the city of Cheboygan, village of Wolverine, and the village of Anacostia.
Chuck?
I just wanted to bring up something in support of Mr. Ormsby's comments, specifically Mr. Bonnet. Mr. Bonnet's farm, he came in about 20 years ago, wanting to get permission to put up windmills on his property. And same justification. His son didn't want a farm, didn't want to take over the farm. He was left to do it himself. Didn't feel he could do it. Came in. We didn't have a solar or a wind regulation. At the behest of our legal counsel at that point in time, we came up with an ordinance, but it virtually excluded any wind development, which is still on the books.
Essentially, with our current wind ordinance, you can put one windmill in the center of a 40-acre piece of property. That's how it works out. So it killed his whole project.
So, I know we've got on this agenda that I just got this afternoon, but we've also got solar, wind, energy storage, and the data centers. If we don't get to any of these others, I would suggest you give us a push, at least on wind. Data centers, I think they're gonna be, I don't think they're gonna get too much flack from anybody here.
I think wind's killing itself.
Yeah.
Wind's killing itself, but we should rewrite the ordinance so that we're not specifically excluding it by the way the regulation is written. Regulation is too restrictive.
all renewables would be reviewed under the workable. 233 covers all renewables.
Tell us if that's your direction to us.
It has to be under the state law.
Right.
We have to look at all.
Thank you.
A staff recommendation, though, a couple months ago, when we started considering a workable first. But as Mr. Lawson pointed out, under the umbrella of P 233, yes, we would have to address everything you mentioned, Mr. Freeze, so it's on our radar.
I
Would
just
data
wanted to
center
make
be
sure
under that?
the direction is that way from the Board of Commissioners.
Just that.
Yep, we all set on part of it. I want to give Joe a long.
Mr. Chair, I just wanted to, if I could please, sir. Regarding the enforcement issues that we obviously have great concerns with, going back to the county administrator, maybe directing that to you, is why haven't we done something in the past 40 years that this gentleman's been there to give them some help? And how do we enforce those, and what civil infraction or misdemeanor crimes would they have to be committing in order to put teeth into that? So if I go out to, Michael's projects or the planning board, and as you said, 100 violations, where do we start, and how do we enact that so that we have the teeth to stop it there at Joe Citizens' business, that they haven't complied with that, and write them a ticket, and they go to the district court. I know that, in our own township ordinances, we've had problems with that because of the fact that the only person that could enforce that in the township was actually the supervisor or his designee, who you put out there. So, I really believe that this is something that we need to look at. We're not really helping you in any way, and I don't see why this county can't afford to hire someone that, in his own ways, as the officers out there writing speeding tickets, he's some way paying for his own, position there. So I really think that we need to take a hard look at the desires of this board, this planning board, and look to put someone in the position of that who would work under, to see he obviously needs to be deputized by the sheriff. Is that the case? Or can you give us some insight into that?
Yeah. Enforcement, there's a lot of levels to enforcement, as the planning commission knows. So I think, as far as moving forward there, what types of violations, I certainly would like to, I'm not saying you didn't see them by any means, but I'd like to know what they are. So, I'll talk about it in general terms. One thing that takes a lot of enforcement in the county, it is kind of like speeding tickets, is junk vehicles. And so if we survey the county, we will have hundreds probably of violations of junk vehicles in the county.
Way in excess.
Yeah, so with that being said, I'm putting in context with speeding enforcement too. Although we have X number of police officers, would we ever have enough police officers to cover everything? So, probably not. I'm not saying we shouldn't enforce junk vehicle, but what we need to do is have a specific type of program for that enforcement. So if that's an area we want to focus on, then that becomes a goal to focus on. On this second level, when you tie things in, our last discussion was like special use permit discussion. That's why, from staff perspective, we're talking about objective, measurable criteria, not subjective. And so a basis of issuing special use permit, if you can measure it and look at it and it's objective, let's say setbacks or landscaping. So if we want landscaping to be more consistent, we should write landscaping standards in. Many ordinances have those. They're not subjective at all. It all goes back to the base of how that plan is developed. That starts at the site plan review process. We don't require sealed drawings for industrial and commercial in the county. Sometimes we get very good drawings, and sometimes they're sealed, and sometimes we don't. And if it's a general drawing that's not very good, it can be very difficult to say what are we trying to enforce under that drawing, because it's just a poor drawing. If you have seals on there, it's quite straightforward what they're supposed to build or not build. That can be measured at the inspection of completion. And so hopefully 98% of everything we ever need to check there is checked off at the end of that project. So there's very little need to go back. If somebody violates something, that's a different story. I don't know how many enforcement officers you need to go around the county trying to look for new things. That's, again, like speeding. I'm not saying it's not important, but it's very difficult sometimes for us to identify where those are. If somebody is aware of that, then they should report that to planning and zoning. And obviously, it's always a balance between resources and what the objective is. So the planning commission's been crystal clear, they want an enforcement officer. The board will look at that, we'll look at it from a financial aspect. I can tell them what that will cost. And if they make the decision, then that's the decision will go. With that being done, we still have to go inside, what are we trying to focus on enforcement? Whether you have 1 or 5, it's like law enforcement. You always have a need for more police officers. You still have to have targets of what you're trying to enforce. I mean, there isn't enough capacity to catch everything. So we need to know, what are these violations, what are we trying to focus our attention on? Because you're never going to have all the capacity you need, just like you don't have 50 police officers to cover everything. There's a balance there.
Would you like a list provided to you?
I would like to know.
Yeah, we
Can
can
you
get,
do that for
Hang on a
me?
minute, hang on.
Yeah,
Careful
I'd
what you
like to
ask
know.
for. Like
one of the other problems with enforcement is it's civil, and nobody wants to mess with them. It takes forever, you gotta have 3 notices, nobody gets a ticket, they don't even show up. Before it was criminal, and all you need is a few of those people on 27 and 33, they get arrested for a zoning violation. Pretty soon, everybody says, man, we better be careful now, and maybe not put that contractor's yard in next to somebody's house, or the porn shop next to the church, or those kinds of things. So, civil and criminal, I know you guys changed it for a reason, we thought it would help. We had a big meeting on that with Catherine, your civil counsel, but absolutely nothing has changed since that time. They did go talk to the judge, but we need something with some teeth. And once the word gets out, you're gonna see that stop, and if it doesn't happen soon, we're gonna ruin this beautiful county. We got the nicest county in the whole state.
I agree.
Well, that's what I want to say, that I addressed both these boards last year, year before, maybe about that same issue of criminal versus civil. There's no teeth in anything if we didn't have an enforcement officer.
Let me walk through that a little bit. You're very unlikely to find an attorney today that would recommend to a municipality to go back to what it was before civil infractions. Civil infractions have been kind of the standard since 1999, 2000, they just left it before that. So if you enforce those from a mathematics standpoint, allow us to do more of those. If you're under criminal, your standards are much higher to meet than under a civil infraction. The court still has the discretion if somebody is trying to get around something or by some means take advantage of the system. The court can move that up to a higher level. So you're not going to find an attorney that's going to say that you should start at a misdemeanor level. The other is, sometimes people just make an error, and if they have that ticket, and that's a misdemeanor, that goes as a misdemeanor on there. It might have been the only time they had a violation. So in the profession, and I don't know of any municipalities, I'm sure there are some that still have it that way, but I'm sure it's well into the 90% plus that use civil infraction. So we have written tickets, even writing them in a civil infraction requires us to go through a procedure, and that procedure is not easy. It doesn't, and the standard would be higher if it's a misdemeanor than a civil infraction. And so if we have an enforcement, sometimes if we don't get cooperation, staff has to go to the prosecutor and basically have a warrant written for us to go on the property. So we can write tickets, we can do enforcement, but understand once you get into the system, when tickets are written, that's under the court system itself. Misdemeanors are much higher. Civil infractions are hard enough for us to move through right now. So we can do that, but that's why you don't see somebody going to that misdemeanor. I mean, if we want more enforcement, then hire a person to do that. Once it gets into the system, depending on what it is, that civil infraction may be straightforward, or it may be a complex case that takes months, could take even a better part of a year, even as a civil infraction to get through the system. So it depends on what the case is.
But having several of those in process is going to get the word out to people that somebody may just go ahead and prosecute you for this.
Yeah.
If they think it's never gonna happen, and that's what many people think, because they told me that. Then
That's
you
why
have
we want
no,
to
you
know
have no.
what the list is.
That's going on currently in the county
We want to know what the
Yes.
list is.
Yeah, they just pay attention. But in your question of what type they are, I can show you buildings that are put up without permits. All kinds of things that are readily apparent. And I've turned them in, and Mike doesn't have the time to do it. And right now, Mike is gonna be short his other planner. And he's gonna, a good portion of his time is gonna have to be devoted to training a new person. Well, he's gone through, well, I've gone through 4 directors.
in your history,
And
That's
all
a good-
planners.
That's a good conversation, but that's why I mean, we have to know what the target areas are. If we're looking at developments that have went in without permits, that's a specific thing. And it's gonna require a specific type of campaign to address that.
But-
It's gonna be more than one person, I can guarantee you that. It's
Well,
a
but
whole
the thing
system.
is,
The
we
system
don't
has
have the
to-
one person to even start.
I understand, I hear that.
And
What I'm saying
that's
is that
where the problem is.
The
That's
person
where-
that's in the field will write that, but it's going to be, it's going to go up the food chain, it's going to go to our attorney, because those are complex cases. I'm not saying we shouldn't do anything about it, I'm saying we can move forward with it, but it's not gonna be that person in the field's gonna write one letter.
No,
and
it's
then
not,
just gonna
but
go-
somebody has
it's
to
gonna go up
start.
the attorney.
Somebody, there has
To
to
the
be a
plan-
start.
Chuck, to the planning commission, we hear you.
Thank you.
I just wanna say again, I more than hear you, I want, you know, I'll make, maybe not here isn't appropriate, but, you know, a demand that we put it on an agenda item at our next meeting to have further discussion into looking into.
Why have a rule if you can't enforce it?
That's my whole thing, I think that we need to start somewhere, I totally agree with you, Chuck, and the bottom line is that if they can't, you know, Michael, when he gives a permit, to tell them at that time, you know, that there are enforcement officers out there, and if you have to go through, that's one of the parts of the blight ordinance that frustrates me to no end, working with the townships, because the way that was set up is, well, they go look at it first, and then they look at it second, and then it goes to the supervisor to make a decision whether he thinks it's, you know, a blight condition before it goes back to the sheriff. And now we're having problems with that office enforcing and dedicating time to, you know, carry on the issues of blight in and of itself. So that's my question that you made. It takes how many steps before it would be a citable offense under the planning? Takes 3 times? So you gotta go out and give them two warning, there's nothing contingent?
No, you can't change that procedure, whether it's a misdemeanor or civil infraction, you have to go through 3 strikes or out.
3 strikes
This
or
is based